Viewpoints on the talk station FM 107 AM 1240. It's always a pleasure to have joining us our as a matter of fact, I think we even got a chair dedicated to him, Professor Greg Wallace, our constitutional law authority, and he's joining us from Campbell University, where he teaches said course in constitutional law. And with that, Professor, good afternoon, and sorry you're not occupying you're occupying your chair at your office here instead of here at the studio, but thank you very much.
Well, thanks for having me.
Let's touch on this very quickly. You overheard my comment related to the issue of federal Judge William Osteen turning back a North Carolina law which establishes a 20-week period of pregnancy for the concept of viability. And you made a comment to me off air a few moments ago that that whole issue of viability is, of course, constantly a moving target due to both medical advances and to, well, actually, quite frankly, new discoveries related to the fetus. But the other aspect, or the baby, the other aspect of this, of course, has to do with the topic of health. And you said a moment ago that that exclusion, of course, is broad enough, as you said, to drive a Mack truck through.
Yes, even after viability, and the Supreme Court clarified in its Casey decision, which came after Roe versus Wade, that the tipping point is viability. Prior to viability, which is supposedly the ability to exist out, to live outside the womb, I have a problem with that whole concept, but nevertheless, after viability, the state can place regulations on abortion so long as they protect the life and health of the mother. Well, the way that the court has interpreted the health exception is so broad that it could be any sort of, even, having a baby would cause mental distress or cause financial distress, which would cause mental distress. And so it really is between a doctor and her woman almost an unlimited right once it gets to the point of birth. And then, of course, as the governor of Virginia, as you mentioned, he was suggesting that maybe even the right to abort ought to extend beyond birth.
It will be, my prediction here, a dividing point. This will be a clear, bright line for voters come the 2020 election. I can't think of, there are a few other items that are going to be pretty important related to, for example, national debt, the topic of, I'll use the word entitlements, but benefits, government benefits, things of this nature. But I would commend to the audience that come 2020, this issue of abortion, and it's unfortunate, Professor, that this is, I guess it's really related to Justice Kavanaugh and the concerns. The liberal wing has just decided that this is going to be the hill that, quite frankly, they're going to die on, or someone's going to die on. And I just prepare the audience for that. And of course, this continues that narrative in the weeks and months and years ahead. Professor Greg Wallace with us. And Professor, I want to move on to other items that are pretty important right now in relationship to events of the day. And I know that the Supreme Court is taking on the issue of gerrymandering, and it's a North Carolina case particularly, which is interested, that has the interest of the Supreme Court. Rucho versus I'm trying to remember I'm going to say, what organization? Right offhand, I apologize. I'm drawing
Women's
a blank.
Voters. Is that I can't remember the other caption in it. There are different ones. Let me see here. I think it is Rucho versus. Well, I don't have it right in front of me.
Common Cause. Common Cause. Rucho versus Common Cause.
Yes, Common Cause. Yes.
Right, yes. So what is the status of that? The Supreme Court heard arguments. Am I correct on that?
Yes, they heard arguments yesterday, or maybe I think it was. I take that back. It was today that they heard arguments in both the Rucho case, which is from North Carolina, and a case that was from the Lamone versus Benesek case, which was from Maryland. In North Carolina, you had partisan or political gerrymandering done by the Republicans. In Maryland, you had it done by the Democrats. And interestingly, our nonpartisan Fourth Circuit struck down the one done by Republicans, but upheld the one by the Democrats. Go figure. But in any event, the oral argument, I think, proceeded along the lines that we've talked about before. How nobody advocates that, and when we're talking about partisan gerrymandering, we're talking about drawing voting districts based on political advantage. Now, that's been something, as I've said before, if prostitution is the world's oldest profession, then partisan gerrymandering is the world's second oldest profession, because it has been around for a long time. Both sides do it. That's what legislatures do. They act in a partisan fashion, whoever the controlling political party is. But the problem is that nobody's saying you can't take political considerations in drawing these voting districts into consideration at all. What they're saying is you can't take them into consideration too much, and therein lies the difficulty. Wow. How do you come up with a standard
of too much
that identifies how much is too much?
Right. And of course, this gets to the issue of a judgment call, and of course, yes, we're talking about that in relationship to the Supreme Court justices making a judgment call. But the question gets down to, how do you? What are the qualifiers? What qualifies this as too much, based on what statistical analysis? I'm wondering, is that one of the arguments that's going to be presented based on statistical analysis?
Well, they have very complex computer algorithms that you can control for geography, political preference, the county lines that are drawn, and you can put in all sorts of considerations that what we might call non-political, that counties don't be divided up, that you have geographical recognition, these types of things. But then even if you put in, and this was one of the questions that came up at the court earlier today, even if and what happened in North Carolina, if you recall, the Republicans, frankly, weren't too smart about this. They drew the lines, and this was for the congressional districts. They said, okay, we want to draw the lines that ensures that in a state that's roughly 50-50, we continue to elect 10 Republicans and only 3 Democrats. Right. And then they did that, and then they went out and bragged that, well, we only did it that way because we couldn't get to, 11-2. Right. We did it 10-3 because we couldn't, which this case is probably the most extreme example, which may not be, for that reason, a good case for the Supreme Court to decide this on. But let's suppose that you have a computer program, you put all the factors in that are nonpartisan, and then you come up with, and what they were talking about today, about 160 different map options. Some of them result in 7-6, or 6-7, or 8-5, or 10-3. Right. How does the legislature know which one of those is a permissible choice? Right. and the question is, and the answer that was given was, well, if you've got evidence that they prove that shows a clear intent to use partisan advantage as the predominant factor. Well, all that says is the legislature's just got to not say anything about why it's doing what it's doing. So it's tough, and the problem is that you don't want to get to a thing where they call proportionate representation, where in every legislative district you have to have an even 50-50 split between Republicans and Democrats. That's just impossible. But if that's what this is going to require, then how do you ever administrate something like that?
Well, and then what you end up doing is you actually end up dividing counties and conceivably even cities and municipalities between congressional districts, which, of course, would be abusive, I would argue, for the voters. We're looking at this case, and of course, this is a big case, Professor, and again, Professor Greg Wallace with us. And by the way, it is the League of Women Voters versus Rucho, and a Common Cause was involved in it, but they weren't the lead. The question I have is, looking at this case, does this case have, shall we say, national influence, or is it just going to reference North Carolina?
Oh, I think it has clearly national influence, and this was one of the concerns that several of the justices expressed today. They said, well, okay, we could say, well, this is the most extreme example we've seen, and as it applies to North Carolina, this is unconstitutional. But that doesn't give us any sort of standard for other cases. And the problem is once they devise a standard, then in every one of the 50 states, you could have people bringing lawsuits challenging the districting every 10 years in all the 50 states. So this could have considerable impact, and even Justice Breyer was concerned that this is where judges are deciding these things rather than legislatures, which he was concerned that really was not the right party to be deciding this.
That, and also it strikes me that this is going to tie up the whole issue of redistricting nationwide, state by state by state. We would be seeing one suit after another from. And by the way, we think in this in terms of Republican and Democrat, but then you add in Libertarian or Constitutional or Green Party, any number of the alternative parties. I'll use that description. To the primaries being Democrat, Republican, this could tie up districting across the country, could it not?
Yes, it could. And I think the Supreme Court does not want to put itself in that position where whatever decision it makes, it's going to stir the pot of these lawsuits, and you're going to have lawsuits in every single state or most every state. Wow. Now, in some of the blue states, what do are Republicans going to sue because Democrats outnumber them and Republicans can't get any of their people elected? Same thing with red states on the Democrats' part. So it's just there's no easy answer to this.
All right, we're going to continue this conversation in relationship to the Supreme Court here in just a few moments. We have joining us for another 10 or so minutes the professor of constitutional law at Campbell University, Professor Greg Wallace, here on the Talk Station. Always a pleasure to have him here. Looking forward to talk quickly about the issue of the Supreme Court expansion, a proposal that's being bandied about, and then we'll chat briefly about the Mueller Report as well. Stay with us here on Viewpoints on the Talk Station FM 107 AM 1240. Viewpoints on the Talk Station FM 107 AM 1240. All right, we've just heard a comment a few moments ago from Professor Greg Wallace related to the issue of gerrymandering. We're talking about the Supreme Court, and with that professor, and of course, Professor Greg Wallace, Campbell University School of Law, where he teaches constitutional law. Just for a few minutes, this possibility of expanding the Supreme Court, another term for it is packing it. It was attempted once before, well, several times before, most recently by FDR, as I recall. The whole issue of the Supreme Court, I'm curious, have the justices themselves given any inclination about those remarks, or is this something that, because it's political, they stay out of?
Yeah, I think that's right. Now, what's interesting is the Constitution does not set the number of justices. The Constitution requires that a Supreme Court of the United States exist, but it doesn't say anything about how many justices can sit on it. And I think it would be chaotic if you start adding more justices to the Supreme Court just so that your party can get a majority in it. I don't know. The American people may accept that today, but they didn't accept it when Roosevelt proposed it, and he did so because he wasn't getting the kind of decisions that the Supreme Court initially overturned a couple of the laws that were a part of his New Deal plan, and so he said, well, I'm going I'm going to pack the court, and then eventually you had a couple of justices do a 180 and start voting to uphold those laws. Whether it was effective or not, even the threat, I don't know. But it wasn't very popular because it was sort of an obvious attempt at manipulating what, at least in theory, should be an impartial institution.
You know, we've talked about this in the past, and very disconcerting and troubling for me, because I look to the Supreme Court, and we've chatted about this on several occasions, but I look to the Supreme Court for an unbiased, thoughtful, wise decision. Wise in the sense of understanding the intricacies of law, but also wise in understanding the long-term ramifications of their decisions. And it strikes me that when you hear arguments such as expanding the Supreme Court, or even the criticisms of the various justices, and yes, they are human, but it cheapens their effort. Am I, right or wrong in that effort?
Well, I think it does, and I think, you put 15 or 20 Supreme Court justices up there, and it starts looking like a legislature and not like a court.
Right.
And I think it would start functioning like a legislature, where you have political deals and compromises and behind the scene backroom kind of negotiations and that kind of thing. I just think it's an unwise thing, and I think the only way the Democrats or the Republicans could be able to do that is to control both the presidency and both houses of Congress. And so whether that would happen, I don't know, but it does seem like, the Democrats could, they've been threatening it, but I think for the most part, these are pretty much empty threats. They don't have the power to do it now, and I don't think they would eventually do it anyway.
But at the same time, I do appreciate the fact that we are looking into the Supreme Court. We recognize the value of the Supreme Court. I do have a quick question related to the 9 justices, or heaven forbid, be expanded to 11 or 13, an odd number, obviously. But when you're looking at Supreme Court cases, whatever it may be, and there are a variety of them, we only see the mountaintop cases. There are, how many cases usually determined in a year? Just for a quick
roughly 100.
100, okay. Many of them we know very little about. Obviously, as the various attorneys, the representatives of the cases are making the presentations to the court, I would think that the attorneys in these cases who are presenting the arguments are thinking of these arguments in relationship to, well, I'll use the word personalities of each of these 9 justices, and just how those justices have historically interpreted a segment of the law. And so, therefore, they're tailoring their arguments, recognizing they've got to convince a Ruth Bader Ginsburg or a Thomas Souter or somebody of this nature. They've got to convince them that how they want to present their case. Am I thinking pretty accurately on that?
Yes, and really, it's oftentimes really much narrower than that, because if these advocates know that the court is going to divide, on party lines, liberal versus conservative, then they're going to be aiming their arguments at the 1 or 2 justices on the court that they think are the swing votes. Like, for example, Justice Kennedy was much more powerful practically than the other justices on the court, because he was often the swing vote. He would be the one that would be the provide the 5th vote to one side or the other. And so when the advocates would go into or make their arguments, they would all be tailored to Justice Kennedy.
All right. Interesting. Professor Greg Wallace, a little bit of history there with us this afternoon, constitutional law professor at Campbell University School of Law. All right, Professor, let's talk about the Mueller, or is it Mueller? I'm never sure. Mueller Report and the disclosure thereof. What is the law associated with this decision? Does the Attorney General have the privilege of releasing all of the documents? And to whom would he release them if he were to do so?
Yes, and yes, he does. It is really within his discretion. Now, there are Justice Department guidelines, and as a general matter, when the Justice Department or the U.S. attorneys or even a special prosecutor decides not to bring charges, generally those reports stay private. Because they don't want allegations getting out in the public and sort of taking on the imprimatur of the imprimatur of the Justice Department, even though they've decided not to prosecute. So, for example, there may be some things in this report where Mueller says, well, this might be obstruction of justice. We couldn't tell, blah, blah, blah. And then somebody could seize on that and say, well, obviously there was obstruction of justice and damage the reputations of, ordinarily it's private citizens, but so there are some Justice Department guidelines for there, but he does have the discretion to release the entire report unredacted if possible. But and I think he would probably release that to Congress in response to a request. But I just don't know that he's going to do that.
To your point a moment ago, it then becomes an issue of a court of public opinion too, and it's gotten awfully seemly as it is. It would just be nice just let this go away. As we wrap it up with you, and again, Professor Greg Wallace with us today. We've chatted about this on several occasions, and of course, you've pointed out that there are some key cases before the Supreme Court. One of them, of course, being the gerrymandering case that we were just chatting about. Any other cases that you're going to be watching with a great deal of interest that would have the impact of long-term changes in one fashion or another in this country at this point?
Well, there are a couple of cases. One has already been decided about whether some of the remaining parts of the Bill of Rights that have not been applied to the states are to be applied to the states. The most recent one was the excessive fines clause. There's another case that's going to be decided to determine whether states will be required to have unanimous juries in order to convict, and that one I think is a fairly significant one. But this is a fairly quiet term this year, and I don't think we're going to have a lot of the blockbuster cases that we've had, like the Masterpiece Cake Shop or the same-sex marriage case, or these types of sort of social cultural type of cases that are going to have widespread influence. I just don't see that there's that many of those up there really not any of those up there this time.
So the gerrymandering case is something of real significance this year.
Yes, I think it will be one of the most, if not the most, significant case of this term.
Professor Greg Wallace with us, and I thank you for your time. Stay with me. I'll chat with you briefly off air, but I do appreciate your time as always. Professor Greg Wallace, Campbell University School of Law, and again, he has his very own chair here in the studio, which he is yet to occupy. We'll work on that. Stay tuned. Professor, as always, thanks very much for being with us.
Thanks.